Number 4, Behler v. Tao.
Good afternoon. May it please the court. Jesse Conan for the plaintiff, appellant Albert Behler. Can I reserve 2 minutes?
Yes.
This case arises out of a promise Tao made to induce Behler to invest in one of Tao's companies. The majority below held that Tao unilaterally terminated his obligation to Behler, and he did so after Tao had gained the benefit of Behler's performance. As the dissent explained, that outcome violated basic and fundamental principles of fairness. Now, there's a central question of authority in this case. Did Tao have the power to unilaterally terminate his obligation to Behler?
And what does Delaware law say about that?
Well, Delaware law says that Tao does not have the power to unilaterally terminate a private transaction like the exit guarantee agreement.
I think Delaware might be a little surprised by that interpretation.
Well, under the Delaware statutory exception, the Delaware statutory exception applies to agreements of the members or member as to the affairs of a limited liability company. It's an operating agreement. That's what the Delaware law says.
So do you first have to determine if both were members?
Well, I think you have to determine if the exit guarantee agreement does not fall within the statutory exception in that it is not an operating agreement of the members. And I think by any definition of operating agreement, it's not. It's a private agreement between two people. It was entered before.
Isn't that a question of fact?
Well, to the extent it is a question of fact, I think it would be grounds for reversal here because questions of fact are not supposed to be resolved on a motion to dismiss. But in terms of the statute says that a member of an LLC is bound by an LLC's operating agreement. But the exit guarantee agreement is not an operating agreement, and it doesn't fall within the ambit of the statute. You couldn't create the exit guarantee agreement unilaterally. There would be no way for Tao.
But don't the covenants, the promises made in the exit agreement relate directly to the core functions of the LLC, such that you really can't parse them out the way you would apparently have us do?
Well, I think that the promise specifically that we're dealing with here is the promise to make an exit offer. And that's really a private
But the
transaction.
substance of the exit offer would require a distribution from the LLC, and that's the core function of the LLC that I'm talking about.
I don't think it would require a distribution because Tao is obligated to make that exit offer, but he doesn't have to liquidate Behler's. He doesn't have to have the LLC purchase the shares back. That wasn't the promise. The promise was that he was going to
It does require a transfer of the shares, right? Even if Tao pays for it out of his pocket, it requires a transfer of the shares.
100%. It requires some sort of transfer of the shares.
And the
for Tao to
amended agreement gives the managing member the right to disapprove transfers.
It does. It provides discretion for the manager.
So how does that bite on the private agreement, if it's a private agreement?
Well, it's a constraint on whether Tao is going to be able to perform. Tao has an obligation to either make the offer himself or find a buyer for Behler's shares. And there might be an independent manager of the LLC. Now, in this case, it was Tao at the time he was supposed to perform, but it doesn't have to be, who would have to approve that transaction. And if Tao was unable to get that approval, Tao would be in breach
From
of the
himself, you
agreement.
mean?
In this particular case, it would be himself.
Well,
but
the case in front of us is this particular case.
Right, but we're trying to disentangle these two agreements, and one agreement.
Well, you're trying to disentangle them.
I would like to disentangle these two agreements. One of the agreements instills certain powers in the manager, and that manager was Tao in 2014, but it doesn't have to be. And Tao's obligation to perform would exist whether he's the manager or not.
In 2014, were there any other members besides Tao?
I believe there were, but that's really outside the scope of this motion. I think there were something like 20 to 25 members eventually. I think they might have all been members in 2014, but I don't know for sure.
Can we go back to the personal versus the managerial authority? In your complaint, you say that Tao agreed that if the price of Remark were to hit $50 a share, he would cause Digipac to sell its shares of Remark and distribute the proceeds. He does that as a manager, not in his personal capacity, correct?
Well, in terms of him being able to perform, I think the manager would have to make that happen. But in terms of what the promise was, I think that it seems to me it was a personal guarantee.
Yeah, but
that he made.
Baylor initially, unless I'm mistaken, didn't even want to invest because his concern was that he couldn't get his money out of a limited liability company. And that's not a personal decision. Like, he's investing as a member of this corporation. He's saying, look, I'm wary of it for a corporate reason, not for a personal reason. I'm just having trouble separating out or saying that this was done in their personal capacity. I agree if they said, look, I'll give you a loan of $3 million, and then the terms. But this is not what's going on here.
Well, I think there's two. I think that certainly the first component of the promise that Tao made, I think, has a lot more connection to the operation and affairs of the LLC than the second. The second promise was unequivocal. Tao guaranteed to make an exit offer at the 5-year mark. There was no capacity in which he was making that promise. The complaint says that it was Tao's obligation, and he could choose how he wanted.
What do you mean,
the
sorry, what do
promise.
you mean by no capacity? Why was it not either in his individual or managerial capacity? I'm not sure
Well,
I follow.
I think it was, the complaint doesn't allege it was in his managerial capacity. It alleges a personal obligation. The claims are asserted against Tao personally, not in his capacity as manager. And Tao is the individual that's obligated to perform. And all we have is the complaint, and that's what the complaint
So
alleges.
focusing just on whether Tao signed the, what you want to call a private agreement, repurchase agreement, however you want to call it, as an individual or as the managing member of the LLC, right? What are the facts, what are the kinds of facts you would rely on to show that he did so in his personal capacity?
Well, they were interacting as friends. This was a deal that Tao and Behler entered before Behler was even a member of the LLC.
Well, that goes to Behler's status. I'm asking about Tao's. I'm asking about let's say you've sufficiently pleaded that Tao entered into this in his personal capacity. What are the kind of facts that, if you could prove them, would let us conclude that you were right?
Well, the facts are that the obligation to perform was Tao's. Tao made the promise that.
Yes, although the first part that Judge Singas read you sounds like Tao making a promise about what he would do as managing member, whereas the second part doesn't read that way. So again, I mean, I'm not sure you can answer right now, but what kinds of facts, I mean, and the fact you're pointing to is actually a fact that's in the record in front of us. It's how the document reads. So are there facts extraneous to the complaint and the agreements, which we can refer to, that you would rely on if we were to remit this?
Sure. So I think that first of all, the complaint alleges that Tao understood that it was his obligation. I think if you look at paragraph 9, he actually makes a settlement offer that never really amounted to anything, but he said that he would buy Behler's shares back. So there was an understanding between the parties that it was Tao's obligation. And again, this is a motion to dismiss, and I think Behler's understanding was that it was a personal obligation on the part of Tao.
So when Behler invests, does his status change? Does he then become a member?
Well, Behler invested, and at the point of his investment, I think Behler's understanding was that he was now a member of the LLC, but the investment was made without any paperwork. There were two wires.
There's paperwork, though. Isn't there the governing agreement over Digipac? I mean, that's a paperwork.
Well, sure. There was an initial bare bones operating agreement.
Which
that was-
also says it can be changed, right? The Digipac
Sure.
agreement itself.
Right,
Yeah,
so
that-
isn't this more a due diligence? Your client failed to really read and understand and appreciate Delaware law and the agreement that he entered into when he invested, which gave expansive authority to Tao to change the terms of that agreement?
Look, I think that there's certainly a due diligence component. He would have been better off had he looked at that. But I don't think that changes the fact that Tao made a personal promise to Behler, and Tao didn't have the power or authority to unilaterally invade that promise. He could change the operating agreement in his capacity as manager, but what he can't do is he can't unilaterally terminate this private transaction that he agreed to with Behler. The Delaware
But
statute.
isn't the personal characterization critical? I guess what I'm trying to sort through is, I would guess, perhaps these agreements are more often reduced to writing, but I would guess that it's not unheard of for there to be some sort of a oral agreement like this. And when someone, on behalf of an LLC or some other entity, calls up someone else who is also in the same line of investing and says, do you want to do a deal, put money into the vehicle, doesn't it sort of create an opportunity to then walk away from whatever the written agreement says, because you can say, well, you weren't proceeding on behalf of the entity, you were proceeding in a separate personal capacity. Why shouldn't we be concerned about that?
Well, because I think in this particular case, there were personal promises.
But why personal as opposed to promises that were made on behalf of the LLC? That's what I'm trying to understand.
Because if the promises were made on behalf of the LLC, they would have been made on behalf of the LLC, and that they would have been said, the LLC will buy the shares back. But that's not what the promise
So
is.
because, oh, okay.
So just to be clear about something Judge Troutman asked you before, at the time of the agreements, and perhaps at the time that the money was actually sent, right, at the time Behler cuts the checks or however he pays the millions, Tao had sole control over this LLC. Is that not correct? Whatever titles he may have held.
Yes. Tao
So
had,
it is possible that it is a personal agreement, but that Behler is depending on the fact that Tao can actually make this happen because they have control over the LLC. That is, they can actualize the agreement, they can comply with the agreement, because it's their company, they have control over it.
well, look, I
Absent
think,
that, I assume Mr. Behler wouldn't have entered this agreement with Tao.
I think that's likely, that's a factor. If you had someone promising that he can make something happen, but you didn't think he'd be able to make that happen, then you probably wouldn't.
Well, not only Ms. Tao, but Mr. Behler, right? What person would enter an agreement for millions of dollars who didn't think the other side could actually comply with the exit
Right.
strategy, which is according to the complaint, the only reason why Mr. Behler was willing to invest this much money?
Certainly, Behler believed that this was a promise that Tao would be able to perform when he entered the agreement.
Thank you.
Good afternoon. May it please the court. Karen Klein on behalf of defendant respondent Tao. There are at least two independent reasons why this court should affirm the decision below. The first, as we've been talking about today, is the LLC agreement. Delaware LLCs are creatures of contract. When Mr. Behler invested in Digipac, he automatically, under Delaware law, became bound by the company's operating agreement.
So is there any way the two of them could have written a private agreement that couldn't, for the repurchase, with the terms that are in there, that wouldn't be extinguished no matter what the LLC did to amend its charter later?
With the terms that are in there, I don't believe there is, because the terms, according to Mr. Behler, were that first, if Digipac were to hit $50 per share, then Tao would cause Digipac to sell all of its holdings and distribute that to the members. I mean, that is the core function.
But
Well, no, not to distribute to all the members, just to deal with Mr. Baylor's
On a
investment.
pro rata basis, but he also pled that Mr. Tao would cause Digipac to liquidate its holdings in Remark, period.
could they have entered into a side agreement under which Tao promised and said he was promising in his individual capacity that he would buy out Behler if the share price was not at X within Y years? And would that have been extinguished by the subsequent agreement?
He could have agreed in writing to make an offer to purchase Mr. Behler's shares. However, he still exercised his discretion as manager under the amended LLC agreement.
So a writing was, you emphasized in a writing.
Yes, Your Honor. If you look at the original LLC agreement, there are multiple provisions in that agreement. They afford Tao sole discretion over distributions, management decisions, and the like, but they also provide that the agreement can be amended in a writing signed by Tao. If there's a writing signed by Tao, then that can amend and change
So
the
let me
agreement.
ask you this, very Judge Halligan's question a little bit. Suppose the written agreement, so let's get out of let's not worry about the fact that this is oral and there'd be all kinds of problems around that. The written agreement is that Mr. Tao will put $15 million into an escrow account, and when the stock price hits $50, that escrow account will be delivered by the escrow agent in exchange for the shares going back to Mr. Tao. Then the LLC agreement is modified as it was. What happens?
If there's a modification of the LLC agreement, that requires a writing signed by Tao.
No.
If he signs that writing.
No, there's a modification of the agreement that then provides that Tao has the ability to approve, sole ability to approve or reject transfers of shares. There would be a transfer of shares involved in that pre-existing agreement with the escrow account. What happens then?
Right, well, then that's a difficult question because you had
That's why I
two
asked.
conflicting, you have two conflicting amendments in that case, right? You have the amendment.
the other's not an
Amendment 1 and
amendment.
Amendment 2.
No, the other's not an amendment. It's a private agreement to put the money into escrow, right? And that's all it is. The money's sitting there in escrow. The escrow agent wants to know what to do.
Well, I believe there's still potentially a conflict even with the initial agreement because the initial agreement has the requirement that Tao has sole discretion over everything. That includes transfers. That includes distributions. And so if there's this
And so
discretion
your
left
view
over
is
to
that
him-
Tao could sign a personal agreement and then decide as the managing member not to honor the personal agreement.
I think that would present a lot closer case. I think in this case, it's not a close case whatsoever. There is no personal agreement, and I think
Well,
that's
that's
clear.
to Judge Halligan's point. Isn't that what this turns on then, really?
Whether it's a personal
Yeah.
agreement or not.
Yeah.
I mean, I think that is one key factor. I think there's a number of.
Do you agree that's a
discussed
factual
issues.
question, though?
Excuse me.
You
what was
agree
that?
that's a factual question? He asserts it's a personal agreement.
No, I believe I believe it's from the face of the pleading. It is not a personal agreement. I don't think there's a question of fact.
Well, what about the standard of review that's required on a motion to dismiss?
If accepting all of the allegations of the complaint is true, it is not a personal
Why,
agreement.
why is that?
That is, for two factors. Number one, he could not have affected the agreement without exercising his powers as manager of Digipac. So it was not.
And that's because it involves a transfer of shares at its crux, I take it. Is that right?
Well, I think it's for two reasons. So with respect to the amended LLC agreement, that's correct. However, what Mr. Behler is trying to do is divide the alleged promise in half and only focus on the second half as opposed to the promise as a whole. So the alleged promise as a whole had two prongs, right? The first prong is if the shares hit if the price of Remark hits $50 a share, then he's going to liquidate Digipac's holdings of Remark and distribute those holdings, including Mr. Behler's pro rata share. There's no way conceivable that could be done in Mr. Tao's
So you're saying the
personal
promise
capacity.
as a whole, the first component is something that could only have been done in his managerial capacity, is that
Absolutely,
right?
Your Honor.
Okay.
But why isn't it different to make a personal promise that I'm going to exercise my managerial authority a particular way versus the LLC guaranteeing a particular exercise of authority?
Because
Why aren't those different things? Because I understood that their argument is, our complaint is the former, not the latter.
So are you asking why he could not have
I'm
personally?
a shareholder of a company. Can't I make a side agreement with someone saying, look, if it hits whatever, I'm going to sell it, I'll give you the money? Or whichever way you want to see that. That's just an individual saying, that's what I'm going to do, assuming the agreement, the operating agreement allows me to sell my shares at any time, right?
That's the problem, Your Honor, is that you have to look to the operating agreement first. And if the operating agreement does not permit that, without the exercise
But the
of
operating
manag-
agreement, when he gave the money, when he entered this agreement, allowed for that. And he's saying, I'm going to exercise my authority in a particular way to make sure that your concerns are addressed, so that you will invest.
So I
certain
disagree,
amount of money.
Your Honor, that the operating agreement, when he invested, allowed for this. The
Isn't
operating.
that what the personal power, the individual power that Tao had under the original operating agreement would do? He could unilaterally make these kinds of corporate moves.
In his sole discretion for any reason. He exercised sole discretion over the company.
does-
Well,
With that-
what
that-
more do you need? I'm sorry.
He had sole authority to amend in writing, he had sole authority to decide distributions, and that could only be changed.
And could he do that in bad faith? Does Delaware law imply any sort of good faith or fiduciary duty in his exercise of those rights?
There was no allegation of
No,
bad faith.
I'm asking you about a legal question, right?
Yes, and we believe Mr. Tao did act in good faith.
No, that's not what I'm asking, right? Under Delaware law, if a LLC agreement gives the managing member the absolute discretion to approve or deny transactions for any reason, and the managing member acts in bad faith in doing so, does Delaware law have anything to say about that?
That's a good question, Your Honor. I'm not sure the answer to that. I suspect it would.
It would probably frown on that,
I
right?
suspect it would, yes.
But then wouldn't that just be a defense to the breach of contract action?
Would-
As
would-
opposed to saying you have no breach of contract action.
Would what be a
Again,
defense, Your
we're
Honor?
at a very early stage in the litigation. We don't know where that would go if indeed we agreed that he could pursue these claims, but that might very well be a defense,
What would be a defense, Your Honor? That he acted in good faith?
or didn't act in good faith, or that he
Well, but
couldn't
the-
act in a way that was bad faith. Perhaps that's the best way of thinking about it.
Our argument is that there was no promise to begin with, right? There was no
I
argument
understand,
to
but
promise
that's,
to
the
begin with.
complaint alleges something else, so we're just trying to deal
Well-
with the allegations in the complaint.
I understand that, Your Honor, but our position is that there
I
was.
mean, your client could take the position, I never made that promise.
Well, Your Honor, we also made the argument, and the trial court dismissed on the ground that the alleged promise was indefinite and vague and didn't form an enforceable agreement in the first place. And we believe that alone is sufficient grounds to affirm dismissal.
Would part of the answer to Judge Rivera's question lie in the underlying issue of whether or not Behler bound himself to the amended LLC agreement? In other words, if, as I'm sure you argue, that he was aware of the amended LLC agreement and he acted in conformity with the amended LLC agreement, et cetera, he cannot now claim that he was taken by surprise or that this was a promise that he thought was still enforceable.
That's correct, Your Honor. And, the Delaware law, Delaware LLCs are a creature of contract. The LLC agreement was amended in accordance with the original agreement, as it was required to happen. So that happened in 2014. Mr. Behler complains that was unfair, but the question isn't fairness, it's whether it's happened in accordance with the initial agreement, which it did. However, even if Mr. Behler was not initially bound by that amendment, which he was, years later, 5 years later, he sent a letter to Mr. Tao saying, as a member, under Section 7.2 and 7.3 of the amended LLC agreement, I'm invoking my right for documents, and I want to inspect XYZ documents. And so he himself has said he is bound by that agreement, and he's bound by its terms. And those terms include the merger clause, which prohibits all
Oh, he's saying he's a
prior
member,
agreements.
he's just saying that the amended agreement is not what he's relying on for the money he claims is owed him.
That's
If he
correct.
doesn't have shares or whatever investment he has, of course, he has no argument, right?
He's saying that the amended agreement is not what he is relying on, but however, the amended agreement governs his membership interest in Digipac. And as a member, it bars his claims because there's a merger clause which prohibits other agreements between Behler and Tao.
But was he a member when he prior to his investment?
He became a member upon his investment. So under Delaware law,
So even though he may have he made an agreement with respect to turning over his monies to receive an interest, he was not a member at that point. Do you agree?
when he turned over the money,
Before he turned it over, he made an agreement. If what he says is true, we had this agreement, and I will give an investment subject to certain conditions. So before he turns over the money, he's not a member, is he?
I would say those happened at the same time. So before he turns over the money, he's not a member.
No,
I agree with that. But the agreement is not.
Do you agree that he hesitated? He was reluctant at first to invest. He says, I'll invest subject to certain conditions, correct?
That's what he pled.
Yeah.
That's what he pled. But he became a member upon giving the money. Delaware law is clear that when you give money, whether you sign the LLC agreement or not,
Right.
you automatically become a member. You're automatically bound by that agreement.
And you're saying he could not have had another agreement prior to that time, though?
The agreement he claims he had prior to that time is inconsistent with the LLC agreement and is not valid based on the terms of the LLC.
Yeah, well, he could sue based, right, we could look at it this way. He could sue based on what he alleges is a separate agreement. He'd have to establish that. It's not an easy task to establish this oral agreement and the terms thereof, but he's made an allegation about that. And then if he's successful, of course, I don't remember if the LLC still exists, but those who suffer the consequences of Tao's agreement could then sue Tao.
So
For either
Your-
bad faith conduct or something else.
Your Honor, if I may, I would just like to point the court to,
All I'm saying is the LLC has recourse. But you've got an individual that controls the LLC who enters this agreement saying, I'm going to do the following. Give me your money, and I'm going to do the following. And then he claims that he breached that agreement.
but there's no conceivable way, Your Honor, under what Mr. Behler has pled, that this agreement was with Tao solely in his individual capacity.
Okay, but that, I'm not clear how you read the complaint and can say that, given the stage of the litigation.
If Your Honor reads paragraph 5 of the complaint, it says there were two components to the agreement.
Yeah.
First, Shing and Behler agreed that if the price of Remark were to hit $50 a share,
Yeah.
he would cause Digipac to sell its shares of Remark and distribute the proceeds.
Again, but what I'm saying to you is it not possible to make a distinction between a personal promise to exercise your authority in a particular way versus the LLC entering agreement to say authority will be exercised in a particular way?
I don't believe
And when
in this-
if he breaches the personal promise, he can sue and see if he can get some money from him.
I don't believe in this context there is, Your Honor, because this is clearly implicating his duties as a manager, which under Delaware law is governed by the LLC agreement.
I assume part of why you're arguing in response to Judge Troutman, the Delaware law says that he's bound by the LLC agreement, is that I assume that incentivizes someone who's engaging in such a sophisticated investment as this to actually do the due diligence before signing, agreeing, sending the money, whatever the point of consummating the deal is.
Absolutely, Your Honor, and it creates certainty for LLCs to not be embroiled in these types of litigations where, oh, there was this outside deal or this other deal,
Isn't
side
that really the
deal.
point, too, to Judge Halligan's? It's certainty. You have a governing agreement.
Yes, Your
You can
Honor.
rephrase that I invested based on a personal agreement seems to avoid Delaware's emphasis on the lettering of the LLC.
That's correct, Your Honor, particularly where that alleged side agreement is with the manager and implicates his duties as manager of the LLC.
Thank you.
Thank you, Your Honors.
Could we pick up on that last point? It seems to me in looking at the Delaware cases and the Delaware law that what that aims for is certainty in the agreement, and wouldn't this idea that, no, this was a personal transaction and I invested pursuant to a personal agreement in an LLC undermine Delaware's focus on the
Well,
letter of the agreement?
I don't think so, because obviously private transactions, purchases of shares, transfers of shares occur outside of the auspices of an LLC agreement. These are private transactions. Now, the LLC agreement might impose.
But it's clear he's investing through Digipac, right? I mean, that's clear in your pleading.
Well, sure, he's making an investment in Digipac, and Tao is making certain guarantees with respect to five-year
And why
exit.
aren't those governed by the Digipac agreement? Because he's making those representations, I will do X, cause Digipac to do, the language we heard. Why isn't that governed by the Digipac agreement?
Because as alleged, and with the inferences to which, with Behler is entitled to on a motion to dismiss, it's alleged to be a personal obligation. It's not alleged to be an obligation on the part of Digipac.
And if-
right
and if
now at
the-
this stage.
If the promises are to, in some places, to cause Digipac to do X, Y, Z, which seems to implicate the governance and operation of Digipac, and there's the merger agreement that your adversary referred to, at least in the amended LLC agreement, is that of no moment at all?
Well, I think that that's a good point, in that I think that the scope of the merger clause is the second part of the inquiry that we haven't really talked about. There's one question about whether Tao had the authority to terminate this exit guarantee agreement, and the other question is whether he actually exercised that right through the merger clause. And this is a boilerplate merger clause, and it, the majority and Tao have argued that it's unambiguous. But it doesn't follow from that it's unambiguous in its intent to terminate the exit guarantee agreement. It's only unambiguous in two ways. It's unambiguous in its intent to replace the original operating agreement, and we know that because it says that. And it's also unambiguous in its intent to preclude parole evidence, because that's what these types of clauses are talking about, which are promises that are made in the lead-in to the final agreement. But that's not what you have here. You have a 2012 agreement and a 2014 agreement, and they have different parties. There's a different focus between the two agreements. And what the case law says is that when you have that kind of mismatch between the two agreements and a boilerplate merger clause, you can't conclude that the subsequent agreement was unambiguous in its intent to terminate the earlier agreement. At the very least, the clause is ambiguous. And at this stage of the proceeding, an ambiguity has to be resolved. It can't be resolved on a motion to dismiss.
Thank you.